Can sexual harassment happen outside of work in Florida? Sexual harassment doesn't stop at the office door when the misconduct connects to your employment relationship. Florida law recognizes that unwelcome sexual conduct can create legal liability even when it occurs at company events, during business travel, at client sites, or through after-hours digital communications. Both Title VII of the Civil Rights Act and the Florida Civil Rights Act protect employees when off-site or digital harassment affects the work environment or results in job-related consequences. These federal and state laws apply to employers with 15 or more employees and prohibit workplace discrimination based on sex, including sexual harassment. Florida Administrative Code Rule 60L 40.001 provides additional protections for state agency employees by defining sexual harassment as unwelcome sexual advances, requests for sexual favors, or other conduct of a sexual nature. Sexual harassment claims typically fall into two categories that help explain the nature of the misconduct. Quid pro quo harassment occurs when a supervisor ties job benefits or consequences to an employee's submission to sexual conduct, such as promising a bonus in exchange for a sexual relationship. Hostile work environment harassment happens when unwelcome sexual conduct becomes so severe or pervasive that it creates an intimidating, abusive, or hostile workplace atmosphere. Courts evaluate these claims based on the totality of circumstances, including the frequency and severity of conduct, whether it was physically threatening or humiliating, and whether it interfered with work performance. Sexual harassment can include inappropriate comments about personal life, sexually suggestive jokes, offensive gestures, sharing pornographic material, repeated requests for dates, unwanted touching, or sexual assault. After-hours texts, emails, social media messages, or workplace chat communications may support a harassment claim when connected to the employment relationship and severe or pervasive enough to affect the work environment. Off-site misconduct becomes legally actionable when the setting connects to employment, such as work functions, business trips, client sites, or industry events. Even harassment by non-employees including clients, vendors, or contractors can create employer liability when the company has notice and ability to correct the situation but fails to take appropriate action. A single severe act like sexual assault may constitute illegal harassment on its own, while less severe conduct must be pervasive or persistent to qualify. Employees experiencing off-site or digital harassment should preserve screenshots, saved messages, email records, and other evidence to support their potential claims. If you experienced sexual harassment beyond the traditional workplace, an attorney can help you understand your rights and legal options under Florida and federal law. Contact BT Law Group, PLLC at 305-507-8506, located at 3050 Biscayne Boulevard, Suite 205, Miami, Florida, 33137, United States, to discuss your harassment claim today.